I have it under control now. Thank you all for joining us. On behalf of the Contra County Bar Association Board of Directors, I'd like to welcome you. And as chair of the membership committee, I really want to welcome all the attorneys that's on. We came up with this idea to present something, a series of webinars on different practice areas. I know with the economy, with COVID-19 and the shelter-in-place order, there's going to be an increase in bankruptcies, and a lot of attorneys have communicated to me that they're thinking of expanding their practice area or shifting their practice area into bankruptcy. So I thought, what better way to potentially help you with your decision, whether to add or to supplement your practice area, but to enlist the aid of the experts in the area that's in our own community. And we got a great panelist. We got a board of 3 incredible panelists that I'd like to introduce. First, we have David Arietta. He's a certified specialist in bankruptcy law by the State Board of California Board of Legal Specialization. He's been practicing bankruptcy law since 1994. His office is based out of Walnut Creek. He mostly represents debtors in both consumer and business bankruptcies, with a particular emphasis on more complex matters. So if you have those complex matters or tough issues, David is definitely the person you want to reach out to. And he's also a grad of UC Davis School of Law. Our next distinguished panelist is someone who helped me out when I was an early attorney and when I was looking at potentially doing bankruptcy. And he gave a great presentation for PLI. He does great work with PLI. Carl Gustafson. He is a certified bankruptcy specialist. He's also certified with the Board of Legal Specialization with California. He graduated magna cum laude from UCLA. Although he's a Bruin, I'm a Bear, he redeemed himself by getting his law degree at UC Berkeley. Go Bears. And he's been practicing with the Lincoln Law in Pleasant Hill since 2003, and he has the best logo of any law firm I've seen in the county, so he has that award. The next panelist, Vince Wood. Vince is a bankruptcy attorney, has been practicing since 2014. He's a graduate of JFK. And he's a good guy. I made the connection because I actually attended JFK and worked at JFK, and I didn't make the connection until like yesterday that, oh, this is Vince from JFK. He is practices based in Walnut Creek, and he practiced throughout the Bay Area. He spent over 20 years in the securities industry. He holds a chartered financial analyst designation, and he's also a licensed mortgage broker. So that allows him to work and advise debtors for strategies of refinancing their Chapter 13s and 11s. And without further ado, I'm gonna introduce our first panelist. I believe David is gonna be the first panelist that's kicking off this seminar. And actually, let me just, for housekeeping, if we can have you all hold your questions till the end. If you want to put them in the chat, that's fine. But if we can hold any kind of expected response until the end, would be greatly appreciated. And without further ado, David.
Okay, thank you, Mike. Okay, so let's get started. If you want to do bankruptcy law, you're going to have to look into being admitted in the local federal district court. And we're going to provide an outline, which is going to provide a lot of different links, so you can look to that after the program. For us locally, our district court is the Northern District of California, so you want to seek to be admitted in that court. If you're going to be working in the Eastern District of California, that's a separate one that you need to get admitted into there also. Besides being admitted into the local district court, you're going to have to open up what's called an ECF account in order for you to file cases electronically. Everything is done electronically in bankruptcy court. So you have to get that. We provide a link there. It's basically, we call it a PACER account. You're also going to have the appropriate bankruptcy software so you can input the cases, and that's going to also help you electronically file the cases. The most common ones are Best Case and Next Chapter. I would just comment on those. You should decide if you want a standalone version and possibly network through your office. That's more like Best Case, or Next Chapter, which is cloud-based. If you want to go on that type of platform, look into that. You're also going to have to be familiar with the various rules and codes in bankruptcy. I mean, the starting point is obviously the Bankruptcy Code, 11 U.S.C., etc. Then you're going to have to look at the Federal Rules of Bankruptcy Procedure, and those overlay with the Federal Rules of Civil Procedure. And then you're going to have a whole hodgepodge of other rules. For instance, you're going to have the local bankruptcy rules. You're going to have a local guidelines and district procedures. And then you're going to have written and unwritten particular judge rules and also trustee rules. And you should know that the Northern District and Eastern District bankruptcy courts cover certain counties, and that's all listed on their websites. So depending on which county you're dealing with, it's going to go into different districts. Within those districts, the bankruptcy courts are broken down into divisions. For us right here locally, we've got the Oakland Division, the San Francisco Division, San Jose Division, and Santa Rosa Division. So all of that, we're going to provide the links for all those rules and the websites to look at. Now, those are the basic requirements. Now, what we also recommend next would be get a mentor. Buddy up with someone who can look over your first few cases and answer your questions. I would also recommend that you review one of their cases, and it's just to see how a basic format, what it looks like, what it entails. Next, join an association. There are various associations which will help you get started. The big one for consumer bankruptcy attorneys is the National Association of Consumer Bankruptcy Attorneys, NACBA. We provided their website. They have a ton of stuff on their website. They have a listserv. They have, if you join them, they've got fast case, so you can do research. And they've got a lot of programs throughout the year. And they have a bookstore where you can go back and see past programs and sign up for those. Next, there's the American Bankruptcy Institute. It's a national association. It's comprised of both consumer and business attorneys. That group has, again, the same type of format. They've got programs throughout the U.S. They've got a lot of books. I've purchased some of their books over the years, which are very good in specific areas. The Bar Association, obviously we have the bankruptcy section. We host programs, and it's also a good way to interact and buddy up and ask questions of experienced practitioners. And then locally, there's the Bay Area Bankruptcy Forum, which is a group mainly just of a variety of different professions, bankruptcy attorneys. There's also other professions like appraisers and receivers in that. And they put on local programs on a variety of topics. Listservs, I just mentioned that earlier, but there are a lot of organizations, those listservs are very good. I'm on the NACBA one, and there's every day, you can look at a lot of different questions and see all the answers, and you can go back in time and look for different subject areas and see how they approach them. I would also recommend next get trained. Like I said, those associations, you have to decide where you're going to put your money, where you're going to put your time. They have local and online conferences. A lot of webinars you're going to see out there. NACPA in particular has new bankruptcy attorney workshops, which you can sign up for. Practicing Law Institute, Carl was on that program. They have an all-day program for practitioners, and there's also one they offer free if you can coordinate and offer some pro bono services. Another group that you should know about is the National Association of Chapter 13 Trustees. They open that up to all bankruptcy practitioners, and they have a lot of information on their website, and they also do programs during the year. The Bar Association also has a Lawyers in the Library program on bankruptcy law. If you volunteer for that, you can assist experienced bankruptcy attorneys and learn on the go at that point. And also some individual attorneys and law firms have boot camps for beginners. Our sponsor for today has a specific boot camp for attorneys who want to learn bankruptcy law. And last, the legal resources that I think you got to have, and again, you got to decide what you want to spend your money on and what do you want to get. The big one is Collier's on Bankruptcy. That's been around for forever. Multi-volume, big treatise, but it's going to give you everything you want to know about bankruptcy, and that's the one. It's broken down into generally code sections. So if you have a specific code section, you go look at that, and they cite cases. That's the one that a lot of the courts and the judges will also reference. Next, you'll have Rudder Group on bankruptcy. That's another good series to look at. The one I like over the years, some people know about it, some people don't, National Consumer Law Center. They have a consumer bankruptcy law and practice. It's relatively inexpensive. You can buy the book and they give you online access to it. They give you a lot of forms and they give you a lot of good cites to cases and explanations of different areas. ABI, again, their publications, they in particular, I would recommend there's a book they have, Bankruptcy Overview. You can get it from their store. It's a concise reading. You can easily just read through it and pick up a lot about different areas of law without getting too detailed. I would recommend if you're going to do bankruptcy law, get a book like that and just read through it just to understand the basic concepts. The local bankruptcy court websites, you have to look at those because there's a ton of information on those, not only just about bankruptcy. For instance, the local Northern District site, they have a whole manual about bankruptcy, what it's all about. It's kind of tailored to the general public, but it's good for anybody just to read it and get up to speed on those concepts. And like I said before, there's a lot of information about just how judges view things. Certain judges even have like research binders online that give you a lot of information about different areas of bankruptcy. The last point I want to make is on samples and roadmaps. When I first started bankruptcy, it was a lot harder to figure out what was out there, but now you've got Pacer. Once you're on there, I mean, you can pull up anybody's case, you can search any name, you can search whatever, and you can get all kinds of motions and samples out there that you can tailor to your own practice and go from there. So I would recommend definitely looking at samples on, a basic bankruptcy case on Pacer, or just pull one from a mentor, see if, look at one of their cases and then go from there. Okay. Like I said, we'll take questions at the end. Does anybody else want to, Vince or Carl, add anything to that, or no?
No, thanks, David.
Okay, well,
it looks great.
Now we'll roll right into Carl's session.
Yeah, the only thing, we're getting a lot of comments about the sources. David mentioned a lot of sources. There are many sources, and we'll be circulating the outline that includes the references and sources that we've discussed today. So you should get that shortly after this meeting. Well, I get to speak about what it's like to practice bankruptcy law. And this is, you could do the paperwork, I'm sure. You made it this far. So you can enroll in the places that you need to enroll. You can learn the law that you need to learn probably, but should you? That's the big question that I hope to help answer. Bankruptcy law frequently has different teams. That's one thing that's kind of unique in bankruptcy law. And the nature of bankruptcy work, depending on which side or which team you choose, is going to be quite different. So Vince, David, and I all represent debtors primarily. We will occasionally also represent creditors, with David, I believe, representing creditors slightly more than Vince and I do. One of the interesting things about the teamwork aspect of it, and I'll go over some of the reasons why it often breaks down into creditors versus debtors, besides the obvious one, is that the law frequently will support one side or the other. And so one of the fascinating things about bankruptcy is, as somebody on your team wins, the law changes in your favor, judges' opinions change in your favor. And so you can kind of represent your whole side in certain arguments, which can make it pretty fun and pretty interesting, especially because most of your colleagues on that team will typically represent only consumers, only debtors, or only creditors. Another breakdown in teams is sometimes those who represent businesses versus those who represent consumers. And so you'll often see bankruptcy attorneys that choose to focus on business practices, which often means that they'll engage in a lot of Chapter 11 bankruptcies. And you'll see others that focus on consumer bankruptcies, which will typically make up the bulk of Chapter 7 and all of the Chapter 13 practice. And so the different nature and kind of pace of those areas of law will really influence what it is you encounter as you practice bankruptcy law, depending on which of these sub areas you choose. That's not to say that you need to specialize. Bankruptcy is already a fairly narrow area. And so within bankruptcy, you could practice in many areas and still keep it fresh, doing multiple things. If you do specialize, you may find ways to develop economies of scale. And we'll talk a little bit about the way that we're compensated that makes that more interesting than in some areas. And if you specialize, you may also, rather than economies of scale, choose to create an economy of specialty. If you become an expert in a certain area, then you can save an awful lot of time by being one of the very few people who might know that area of law. And all of those things are available, kind of subspecialties within the bankruptcy practice. One of the big tricky things that makes people often choose one of these sub areas or teams, as I've referred to, are conflicts of interest. Typically, if you represent large banks on consumer matters, you'll have a hard time running conflict checks against the many consumers that may owe that same bank money. And the same maybe with local credit unions or smaller creditors. Typically in a bankruptcy case, I mean, even a regular consumer might have 20 or more creditors. I've had consumers with hundreds of creditors based on generally medical bills, and it'll just be an ordinary person that owes an awful lot of people. So with the amount that that person can actually afford, it means you're running a lot of consumer cases, and with that many creditors, you can run into conflicts pretty quickly if you try to represent both sides. So if you do decide to dip your toes into multiple areas, just pay attention to how you're going to check for conflicts as you get involved in those ways. For rates and fees, the second thing here, bankruptcy is quite unique in several aspects. Bankruptcy attorneys may bill at market rates, but if you are paid from a debtor in a bankruptcy case, then your fees must be approved by the court in reorganization cases. And reorganization means Chapter 11 or Chapter 13. So that means that although your debtor might be paying you, it's your client paying you, you'll need to get permission from the bankruptcy court to access that money and file regular fee applications. And some judges, until they know you and are confident in you, may pay an awful lot of attention to those fee applications. In a liquidation case, which means Chapter 7 cases, if you're representing a debtor, then the court can still reverse the fees and can review fees for reasonableness. So there's a lot more scrutiny over fees between bankrupt debtors and their attorneys than there are in most attorney-client relationships. In many cases, the employment of the attorney or professional must be approved by the court. We won't be exploring that rabbit hole, but if you are intending to work in a limited capacity within a bankruptcy case, you'll want to talk with the bankruptcy attorney about whether or not your employment needs to be approved by the court. And if you become an attorney in a bankruptcy case and you want to hire other professionals, accountants or common ones, and other experts, you need to look into whether you need to file a motion to employ. Regarding actually being paid, Chapter 7 cases, which are liquidation cases, they're generally shorter and generally less intensive than the reorganization cases. The Chapter 7 cases in the consumer context often have flat fee retainers. But one of the tricks you run into when collecting money from your client is you need to collect the money both before the case is filed, because often when the case is filed, the debtor doesn't owe you anymore. So your own client won't owe you any remaining funds, and you can't get them off a credit card or from other debt. The debtor needs to actually come up with the money to pay you before the case is filed. That can be pretty tricky, and all sorts of different attorneys have different ways to deal with it. So that would be one to talk with your mentor about. And it's often one of the biggest hurdles to consumers or debtors that are trying to file a case, whether it be a business case or a consumer case. The initial retainer is common in reorganization cases. So that's a Chapter 13 or Chapter 11 case. And the initial retainer may be quite large, depending on how big a case you anticipate. Again, your ability to receive fees after that initial retainer, and even to transfer the initial retainer to your out of your trust account into your operating account, may be limited and subject to court approval. So your client's ability to pay, they often need to be poor enough to file for bankruptcy and have a good case, but not so poor that they can't pay an attorney to actually run with that good case. Northern District bankruptcy courts, as well as many other courts around the country, will often pre-approve set fees for reorganization cases that deal, or at least within a Chapter 13 context. So those are individual reorganization cases. And what they've done is they've created a menu of what they consider allowable fees. And then once you show the court that your case has certain parameters, meets certain guidelines, and the case is confirmed by the court, which may be some months in, the court will approve your receipt of those set fees. If you disagree and you don't want the set fees, then you'll need to provide for your hourly billing. Once the court's approved the fees, you can be repaid through a reorganization plan, provided that your debtor actually makes the payments. If you're approved for fees, the debtor doesn't make the payments, and the case gets dismissed, you could have done all that work, had it approved by the court, and then there's just no money to get it. So those are some of the hiccups with the way that you actually get paid. In addition, many attorneys in bankruptcy offer free consultations. It's not necessarily required. That's a marketing choice. But the free consult, if offered, as well as several other aspects of bankruptcy, are often anticipated to not be billed. So there is a considerable amount of unbilled time within a typical bankruptcy case. Litigation and bankruptcy is another subsection. what most people think of as bankruptcy is more of a procedural practice that sometimes we'll get into motion work, but there's kind of a different beast that wakes up every so often in bankruptcy where sincere litigation is involved. Litigation can and often does take place within the bankruptcy court, but there's some types of litigation that would be referred out to state courts or even federal courts. The litigation follows the federal rules of procedure, but applies certain types of state law. So having experience in litigation in other venues can be helpful, and litigation entails the same risks in bankruptcy that it does every place else regarding collection and the way you assess the risk of a case and assess the fees. The hours in bankruptcy, many bankruptcy practices are fairly small. And so you may have discretion over your workload by just taking control of how many clients that you accept. And if you're concerned about hours and want a less demanding practice, I mean, that's just like any other solo practice, maybe a little bit less than a litigation solo practice maybe, but you may have control over how much time you spend on your cases. With the clients that you do have, though, you should be aware that many of them will be under stress. Frequently, bankruptcy is one of the most difficult and complicated interpersonal and just kind of self-image issues that your clients will have faced in their entire life. And your clients may, even after your representation has ended, continue with follow-ups and questions and asking you about their credit report and things like that for years after representation ends. Another thing to be aware of is with this kind of tailing workload, you're often paid in the beginning of a case, and then you may have work to do for years afterwards or continuing contacts with your client or ex-client for several years. And so one thing I've seen with several people, heck, including myself as a new practitioner, is it seems like everything's going great for the first few months or year, and then the same clients from the beginning that should be all done continuing asking questions. So the snowball takes a while to form. And in reorganization cases, you'll represent a debtor for several years. 3 to 5 years is the term in a Chapter 13 case, and in Chapter 11, it varies beyond that. And so you may have received all of your pay you're expecting from that case within the first year or so and have a few years left. So when you are making decisions, if you decide to go into bankruptcy, pay attention to that and prepare for it. That's something, again, that you would want to speak with an experienced practitioner to just see how they deal with it. And if you're penciling out what your workload is going to look like, they should be able to help you with that. And the final area is quality of life. We all have a different calculus of how hours to compensation works for us. In bankruptcy, the same calculus goes on. You'd want to take into consideration your appreciation of working with stressed clients. But there's some real benefits to practicing bankruptcy law that really don't exist in a lot of other areas. First, the practice can be pretty predictable, as most bankrupt debtors are screened before you file their case, so you know what you're getting into. Most of the time, you can assure them how a case is going to go if you're representing debtors. You could tell them that unlike all sorts of other issues, medical issues, relationship issues, you could actually just fill out paperwork and make a problem disappear. That kind of magic is pretty unique when you talk about life-changing and ultra-stressful situations. And it's wonderful to watch the alchemy of bankruptcy law when you meet your client from the first time and they're extremely stressed out. And then when you meet them for the last time and they're so grateful and they don't have debt anymore, and it really is a fresh start. And that is, for me, the most gratifying part of the whole practice is watching that change. Keep in mind that many bankruptcy debtors have never had an attorney before. They've never been to court before, and they may be ignorant regarding many issues. So if you've been in a corporate law context or a complex litigation practice or something like that, you'll typically have repeat players. In bankruptcy, at least with debtor representation, you'll be translating and introducing a lot of people to the entire legal system in as much as it applies to them. When you deal with debtors, when you're dealing with creditors, creditor representation is also a little bit calmer and more predictable. Essentially, when you're representing a creditor in bankruptcy, their prospects of collection are generally so poor that they have very muted expectations of you. And so the conversation often deals with choosing the least bad outcome, and that can reduce the stress of the process in some senses. It still may be a stressful litigation process to get to that outcome, but you're often able to, with some experience, be able to predict something near where the outcome will be and set clients' expectation near where you end up getting it to. And that can be quite settling for a creditor's attorney. Many bankruptcy bankruptcy courts also have different rules of procedure. There are all sorts of unlimited, unwritten rules, as David kind of alluded to. And if you do master those rules and figure it out, it can make for a real home court advantage and make you feel very comfortable in bankruptcy. And if you see a non-bankruptcy attorney come in and maybe sweating, and you've earned the right to be cool and collected in court. The bankruptcy practice is also small. Pretty much everybody knows each other, so the practice tends to be very civil and amicable, and you keep up with each other. You hear news of glorious victories, and you can see the effects of your own and others' work. If you are to start doing bankruptcy, you would probably wish to create an on-ramp for yourself where you start by focusing on the simplest of cases and then build up once you get the basics down. Even filing a fairly simple case does take quite a bit of knowledge, takes filling out a whole lot of paperwork, a lot of communication, a lot of reading documents that will later become routine. So you'd want to figure out how to identify and then acquire some of the simplest debtor cases. And then over time, you'd probably wish to upgrade to taking more complex cases. That's something that you can do with a little bit of guidance where you identify which cases are going to have issues. But it is something, again, where a mentor giving you a second, double checking that there aren't any skeletons lurking in the closet of any particular case would be highly recommended. So that's kind of the nature of bankruptcy, how some of the pros and cons of actually practicing bankruptcy law and some of the unique factors of it. It may be total anathema to you and make you run away and not wish to have a judge reviewing so many of your hours before you get paid. Or there may be some other aspect of it that really draws you to bankruptcy. And if one of these things is just positive in your decision making, then wonderful. I hope I've been helpful. And if you're still on the fence, then you can always reach out to somebody that practices a lot of bankruptcy and talk over your thoughts. It's quite a unique practice area, so it'll be a fantastic and interesting conversation. Vince or David, do you have anything to add?
No, I think we could address some of the questions that are coming in. We can address at the very end. I don't think there's anything that's specific to the section you just talked about, but we can address all those. And I think, and you correct me if I'm wrong, but I think we can go over the hour to give some time for questions. If you have questions out there, feel free to submit them. We can answer them at the end.
Yes.
Okay.
Yes, you can.
Great. Then Vince, I'll turn it over to you.
Okay, thanks, Carl. So just wanted to make a quick point about what Carl was saying. I mean, I selected bankruptcy because I had a financial background and I wanted to gravitate towards a financial area of the law. So if anybody out there is more comfortable with financial concepts, it's a little easier, I think, to get into it. But and then before I start, I also wanted to make a comment about the title we used, Dark Side of saying, do you want to get into enter the dark side? And I think we came up with that title because a lot of clients, when they come to us, they've depleted their bank accounts, 401ks. They're being inundated with phone calls, wage garnishments, bank levies, foreclosures, repos. And for them, it really is the dark side. And it's an opportunity to be a hero for these people. So it's a really rewarding area. It's also, bankruptcy, as you know, has a stigma to it. Probably not as bad as it used to be, a long time ago, but right now there's still a stigma, and most people are embarrassed by filing. And so I try to approach this practice as a financial planner in a way. So you're not managing their assets, you're really just managing their debts. You're trying to clean up that side of their balance sheet, and you try to do it in a clinical way. And I think people really do appreciate it, and I think it's a very rewarding area. So I just wanted to make that comment. All right, so getting to my section, now David talked about what it takes. Carl talked about what it's like to practice, and both of them talked more in big picture terms. And I'm going to try to drill down into the steps of what it's like to go through a typical bankruptcy case. Now, when we say typical, I gotta qualify that because there's a lot of flavors of bankruptcy. There's chapter 7, 13, 11. There's even chapter 12 and chapter 9, but I'm obviously going to talk about some, the garden variety, chapter 7, that you're probably going to see if you do these cases. Okay, and I'll try to throw in some key pointers as I go in through each of these stages, and try to give you a flavor of what to expect all along the way. So, all right, so the first step is usually the client interview. So generally speaking, most attorneys, they offer a free consultation. It's usually a 30-minute consultation, so that's pretty much the industry standard. So if you're going to do consultations and you're going to charge $400 an hour, you might not get many people signing up because a lot of people do offer it for free. So I would just recommend do what everybody does and just do it for free. Sometimes attorneys like doing it in person. Others like doing just phone consultations. I know there's different philosophies there. I tend to like the phone consultations only because sometimes people flake. You don't waste a lot of time if they don't show up to the meeting. Sometimes bankruptcy is not right for them, and you can determine that in that initial consultation and then move on and not waste a lot of time. But I think others have different philosophies on meeting in person too. So either way, I think it's important to make sure you keep the consultation on track. It's a free consultation, and people will take advantage of that. They'll spend a lot of time asking you questions about other areas of their life or just unloading all their life story. And they don't respect the freeness of it. So you got to keep them on track, and just cut it off at 30 minutes. That would be my advice. These consultations are also really useful to determine how much work you're going to put into these cases. So use it as an opportunity. And I'd say if you're getting into this and it's new, try to avoid adversarial situations. So people that are going through a crazy divorce, or they're litigating probate, or they're going through some business litigation and they want to now file bankruptcy, I would try to avoid these cases if you're new, because these issues will bleed into the bankruptcy court, and then you're going to be filing and fighting these issues, and you're getting paid a flat fee. So it's probably not worth it. I'd say try to ferret that out at the initial consultation and just refer it to somebody else or just avoid them altogether. All right, so that's the consultation. Obviously, you need to get retained, so usually it's just the contract and payment at that point. But once they retain you, then we need to start gathering the information. Now in bankruptcy, debtors are required to disclose everything they own and everything they owe. And so most attorneys will use these these information packages to gather that information. They're usually user-friendly formats, so it's a little easier for people to fill in their information. And then we take that and build the schedules in the format of the bankruptcy forms. You also need to get them to fax or mail tax returns, pay stubs, mortgage statements. So sometimes it's challenging when people don't know how to use a fax machine or they don't use email. So there's always a challenge sometimes with text challenge clients. I'd say maybe 10% of the time we run into that. You got to allow for a few rounds back and forth maybe, but I'd say that whole process might take around about a week or two. One thing I would note that clients like to hide information, or sometimes they hide information. I shouldn't say they like to, but they'll hide assets and debts. And bankruptcy requires full transparency. You need to disclose everything. And people don't always do it on purpose. I've had clients who are from foreign countries who've inherited property. I had one in the Philippines, so they had this piece of land that they didn't know about. So when you disclose your assets, it's worldwide assets. You have to remember that. It's not just US assets. And then sometimes debts get left off, like family and friends. They're not really formal debts, but they're technically debts that you need to list. So make sure you ask those types of questions. All right, that's the information gathering. Okay, then we take all that, and then we usually have a staff, somebody on our staff will build the petition and the schedules, either paralegal, legal assistant, and then the attorneys will then review those schedules with the client to make sure they're accurate. I don't think we've mentioned credit counseling at this point. There is a credit counseling certificate. I won't go too far into this, but I describe it as a like traffic school for bankruptcy filers. It's an online course. It's a budgeting exercise. It's not hard, but when you go through it, they'll issue a certificate at the end, and then you need that certificate to file the case. So you need to gather all those documents, prepare everything, get the credit counseling certificate, and then the client needs to sign a review. They need to sign before you file the case. That's really important. And there's no e-signatures. They have to have an actual signature. So that's it. This initial stage usually goes around 2 weeks to prepare the filing. When everything looks good, then we file the case. All right. Now, there's two ways to file the case. One is obviously directly at the courthouse, and the other is with ECF that Dave mentioned earlier. ECF is by far the most used. It's preferred. It's a 24-hour system, more convenient. But I will say that ECF is also very manual and labor intensive. So there's probably about 20 PDF documents you're going to have to upload one by one using the ECF process. So the nice thing about these software programs like Best Case, and I think Next Case, is they use these automation scripts to do the manual upload for you. So when you hit a button, it'll just run the script. It takes control of your computer, and you'll see it. And you'll see your computer moving around doing all this manual stuff that you would have had to have done automatically. So I'd say it's probably worth getting one of those software packages just for the filings. Save you some time. Okay, so once you file the case, it generates a notice of filing, and it's a document that shows it's the time and the date that you filed. And at that moment in time, the automatic stay takes place, and that stops all debt collections. And that document's important because sometimes you need to prove it. You'll have a creditor that won't stop, and you need to show them that your client's in bankruptcy. That notice of filing is very useful. All right. The next big milestone is called the meeting of the creditors. And it's sometimes known as the 341 hearing, and that refers to the code section under Title 11 for bankruptcy, 341. And it's usually the only hearing your clients need to go to. They're held at the federal building. So if in Contra Costa and Alameda, it's in Oakland, but there's other federal buildings in the other divisions. These hearings are run by the trustee. They're not run by the judge. Your clients are under oath. Usually the trustee will schedule this around 30 days after you file. And you and your client are usually the ones that have to attend. And if you don't attend, they're going to dismiss your case. It's a mandatory meeting. And at the meeting, the trustee is going to verify your client's identity, social security number. They're going to review things for accuracy and completeness. But the main purpose is for creditors really to ask questions. But ironically, no one usually shows up. They rarely attend. Credit card companies, mortgage companies are never there. They usually object online if they have a problem. The only time I see people showing up are angry spouses, angry business partners, angry landlords, angry private investors. So you get the pattern here that it's usually somebody who has a personal relationship with them that's just pissed off. And then it turns into a mini deposition. So you got to be ready for those, or you just avoid those cases altogether if you think it's going to create that. But for the most part, these are pretty routine meetings. They're required. They generally are going maybe 5 to 10 minutes and then you're done. So it's nothing to really be stressed about. Clients are usually stressed, but usually you're in and out pretty quickly. Normally it's an in-person meeting. Getting through security can be challenging. You know, people forget their driver's license and they can't even get through the metal detectors downstairs. Lately, we've been having Zoom meetings, and there's technical issues there where people just don't understand how to use Zoom or activate the audio. So just, you know, there are some things you need to do to handhold your clients with the meeting of the creditors. Okay, moving on. So now you're done with the meeting of the creditors. The next milestones are really the deadlines. The first deadline are the claims deadlines. So the way claims work in bankruptcy, it's a three-step process. We as attorneys start the process by listing all the debts in the schedules. Then creditors have a chance to file their claims. Now, our role is really just describing debts. There's no way we're going to know what the actual number is. Creditors do the accounting, so when they file their claim, that's the number the courts are going to use. So that claim is really important. Now later, the third step, you have an opportunity to object to that claim if you don't like it, but that's how it works. So we start by describing it, they file the claim, and then you can object to the claim. Now, once you file bankruptcy, the trustee's going to set a deadline. They have 70 days to file their claim. If the creditor doesn't file a claim, they're not going to get paid. I think in these Chapter 7s, claims are not really going to be much of an issue for you guys. Usually people are insolvent. It's usually credit card debt. Claims really don't matter that much because the whole thing's going to get wiped out. If you're getting into Chapter 13s, it becomes more of an issue, but just know that they need to file their claim, and then you need to object if you have an objection pretty soon after that. Next key deadline is the objection to discharge. This is really kind of the last key deadline. They have 60 days after the meeting of the creditors to object to dischargeability. Now, for those of you who know a little bit already about bankruptcy, certain categories of debt are non-dischargeable, but they have to allege it. If they don't say anything, you can get through and get a discharge on something that may be objectionable. The most common that we see, I mean, these are all rare anyways, but when you have one, the most common are fraud, embezzlement. You can't discharge those. You can't create a debt through crimes and then try to discharge them. So people will try to object on those bases. The other more common one is people running up their credit cards right before bankruptcy. So if you see someone trying to buy jewelry or coins or a watch or something crazy right like 90 days before, there's a good chance that they're going to be objected to by creditors. I don't want to get too far into it because we're going to try to keep this moving along. But if they don't object, then maybe your client can actually get those discharged. But the deadline is 60 days after the meeting of the creditors. All right. So at this point, now in the case, we've finished the meeting of the creditors. The claims deadline has run. The deadline to object to dischargeability is run. If there's any remaining issues, kind of at this point, it kind of depends on how the objection evolves. I mean, if it's close, you just ask for continuances at these hearings. Eventually, the judge will lose patience and start scheduling evidentiary hearings and trials, but that's how they would get resolved. Again, that's pretty rare. You're not going to probably run into those, but most of the time, there's no outstanding issues. Trustee will recommend confirmation and then upload an order, and then the judge will sign that order. So it's a discharge order, and that means your client is no longer personally liable for those dischargeable debts. And now you have a court order that says that. You can show people if they ever try to collect later, you have a court order. One point, there's a difference with Chapter 7s and 13s on the timing. Remember, the discharge comes at the end of the case. So in a Chapter 7, it happens at this point that we're going through. But in a 13, you have a 5-year plan. And a lot of times people get confused. You need to finish the 5-year plan to get your discharge. It doesn't happen at the beginning of the case. And sometimes people get confused. So if you fall out of your Chapter 13 and it gets dismissed, your debts are still there. You need to finish it, get all the way to the end to get the discharge. Okay, and then 2 more points, and then we'll open it up. With the credit counseling, we mentioned that there's a pre-bankruptcy filing counseling certificate requirement. Well, there's a second course that needs to be done before you get the discharge. It's pretty easy. It's a review of the first course, I think. It's pretty simple, but it's another certificate, and it just has to get done. Sometimes people forget that, and but the courts won't issue a discharge until the counseling certificates are filed. And that's pretty much it. I mean, sometimes if you get the occasional creditor that will still try to collect a debt that's been discharged, You can reopen the case and file a lawsuit, but again, that goes beyond what we're talking about today. But just to summarize, it takes about 2 weeks to prepare the case and probably about 4 months to get to the end, discharge. I would, I think that's pretty much the end. I think there's one more comment I'd like to make. I think Carl and David and I, we all went through, there's times when bankruptcy is really popular and times when it's not. And the last time bankruptcy became really popular was during the Great Recession, when we had that mortgage meltdown crisis in 2007, 8, 9, 10. And we saw a lot of new attorneys jumping into this industry, and there was a lot of mistakes made. So I would just caution, the biggest mistake people made, I think, in my opinion, you guys may chime in on this, but on these second mortgage lien strips, you guys might read about these, you can strip off a second mortgage if the house is underwater, but you can only do it in a Chapter 13. So if you're facing a potential lien strip situation, don't file Chapter 7, because all it does is discharge the debt. The lien's still there, and 10 years later, these creditors have started the foreclosure again, and everybody thought the debt was resolved, but the lien is there. You have to use 13 to strip the lien. So then there's other things. I just caution you to make sure that you guys ask a lot of questions and ask a lot of questions of other attorneys in the industry, so that some of those mistakes won't get made too. So other than that, I'm done. I'm happy to answer any questions that people have. And Dave, Carl, if you have any additions, feel free to jump in.
Vince, we have a question about where the trustee. When is the trustee appointed in the process? And when does the trustee come into the process in a 7?
Okay, well, with Chapter 13s, there's really only one trustee, and she's always off. It's Martha Berninski in Oakland, and they're always assigned right away at the beginning of the case. It's really automatic. You don't really have to do anything. And then with the Chapter 7, I think there's about 6 in Oakland, and there's a rotation. You don't know who you're going to get, but they're usually just automatically appointed. So that's one of the nice things. You don't really have to do anything. But it usually happens right away. Hopefully that answers it.
Okay, there's some other questions coming through on the chat. So it looks like there are 2 ways to ask questions. One is called Ask a Question, and the other is the chat. So there's another one here about explain in basic terms the role of the trustee, to whom he or she owed duties. Maybe I can handle that, and then David, there's another one after. So in either 13 or 7, the appropriate chapter trustee has duties generally towards the creditors as well as to the integrity of the system. So the trustees have certain duties regarding the integrity of the system to report certain suspicions that they might have regarding hidden assets or attorney malfeasance or other things like that, and refer cases for investigation or audit. But generally, their role is to maximize the return to the unsecured creditors. So rather than what may be a dozen unsecured creditors or more all having to hire attorneys to police the case, the bankruptcy system requires that a trustee be appointed, and that trustee looks to see if there's any value in the case for the creditors. And if there is, then the trustee will make sure that that value is realized through all of the powers that they're given in the bankruptcy code. That's a overview of how it works in either 7 or 13. The way that they go about it is different. We call Chapter 7 a liquidation case because the Chapter 7 trustee will sell assets and use the proceeds to pay the creditors. Chapter 13 or Chapter 11 is a reorganization case. Chapter 11 is different, so let's set that aside. But in Chapter 13, the debtor will propose a repayment plan. And the trustee's role there is to make sure that the amount of the repayment is sufficient. And then the trustee receives those repayments and distributes them to the creditors as the repayment plan goes on.
Okay, we have another question about what is a reasonable estimate of the amount of hours a typical Chapter 7 case would take? I mean, I would say from my personal experience, I mean, I don't keep hours per se on a Chapter 7 case. It's kind of a hard thing because, I mean, on one hand, you're basing the cost of the case on kind of like industry and what other people are kind of charging for consumer cases, but then you've got, more complicated consumer cases and you got business cases. So it's hard to just figure out, well, it's going to take me 6 hours or 7 hours, and that's what this case is going to be worth. And Vince or Carl, how do you guys view that?
I mean, I would just add to that when you're first starting out with anything else, you're going to put more time into figuring this all out. But I think with Chapter 7s, it tends to be a little bit of a low margin, high volume. It can be that way. And so once you figure it out, and it'll be fairly routine. And so you will be spending a lot less time on each case, but you're not going to get rich on each of these Chapter 7s either. So, but I think initially it'll be more time. I don't know how to quantify it, Dave. Sometimes you can, if you're doing it by yourself, it's going to be harder because you're going to prepare all the petitions. If you have good help, like legal secretaries or paralegals helping you with the schedules, then they can do a lot. I mean, obviously you've got to do the legal work, and you don't want to put too much on them, but that's what happens. You get some help there, and you're not spending as many hours on each case as you get going.
Yeah, and I don't have a whole lot to add. The range in cases varies. Typically on the lower end, the cost is going to be maybe a little bit under $2,000 in attorney fees. And on the higher end, it's going to be 4 times that if it's a business case, 10 times that or more, just depending on what's going on. So there's quite a range in assessing what happens and what it's going to take is part of what you'll do. And they may interview several different attorneys like they would in any other context and come up with different approaches and different quotes. So there's a market constraint on it as well. There's another similar question about the range of flat fee for Chapter 7 and Chapter 13. The 13 for consumers is actually easier because the court has set fixed fees for Chapter 13. Now, attorneys can and really should, in my estimation, opt out of certain fixed fee costs because the amount required in a Chapter 13 can be substantially higher. But if you run a typical Chapter 13 case, the base fee is $4,500. And if your debtor goes all the way through it, then that's what you can count on being paid. The fees can go up from there depending on what's involved in the case. And that's the Northern District of California fixed fee. Vincent, David, have you ever, there's another question here. Have you ever recused a trustee that you don't like?
I haven't, but I mean, I don't think I've ever heard of a conflict of interest or, remember, they're not really ruling on issues. That's the judge's role. They're really sort of playing a logistical role here where they're trying to make sure things are accurate. They do a little probing to make sure you're not hiding assets and hiding debts. But really the judge is making the tough decision. So I don't know if you need to recuse a trustee unless there's a clear conflict of interest. I don't know. Never seen that.
Yeah, I would just add, I've never seen where you can recuse them because you don't like the trustee. I mean, I've had several cases this past year where the trustee had a conflict. Either I don't know, maybe some party went to them in their private practice or, something like that, or they had a conflict. So then they take the steps to, remove themselves.
There's another question in the chat. Is the Chapter 7 trustee required to sell property at the highest possible price or just hold an auction and sell it to the highest bidder? I think, following an appropriate method would be sufficient for a Chapter 7 trustee, but the question is kind of irrelevant because trustees are paid a commission based on how much they distribute to creditors. So your trustee is likely to sell it for the highest price. And if that involves an auction, that's fine. If it involves something else, they'll do that. The trustees are pretty good when they smell blood in the water. When they smell money in a case, they're pretty good at pursuing it. That's how they get almost all of their income.
Yeah. I think these trustees will hire a real estate agent. I don't think they auction it. I think they actually will get their own agent, as I understand it. I don't normally see that because usually people are losing it to foreclosure first, or they try to do a graceful sale, like a 6-month sale plan in Chapter 13, where you just are listing the house for sale with Chapter 13 and make payments along the way and sell it within 6 months. You usually don't get caught in a situation where the trustee is going to liquidate the house, but I think when it happens, they get their own agents. They don't just auction it like they would on the courthouse steps. Correct me if I'm wrong, I don't know.
I've seen other assets auctioned, but it generally doesn't happen with real estate. And when they auction it, it typically won't be within the bankruptcy court. They'll employ some other real estate auctioneer professional to do it in a better way than, and to fetch a better price than foreclosure would. And then we have 2 more questions here. One, Vince, maybe you can answer this. In general, how vulnerable are principal residences in a liquidation? And how about in a Chapter 13? And does the court bend over backwards to leave people in their houses?
Well, I think the courts are very sympathetic. I mean, these are people. The judges are people. The trustee. Everybody wants. It's kind of rooting for you guys, or for the the clients. But they are trying to be a referee here, and you've got creditors that want their money out. So at the end of the day, if your clients cannot afford the house, they're going to tell your client you can't afford it, and you're going to have to let it go. So they do have their limits, and because they're trying to balance the interest of your clients against the interest of the creditors at the same time. I think if you can show that they have income and you can propose a plan like a Chapter 13 and it looks feasible, they'll be lenient on that. But you know, again, Chapter 13s are like a big forbearance. You're just paying back the arrears. You're not changing the loan. You're not forcing a loan modification. So it comes down to feasibility. If they can afford to make the payments, the mortgage plus the arrears, then they usually will get approved if they can show that. If they miss their payments, they're not going to be that lenient, and they're just going to let the creditors take the house. And it doesn't matter if it's a primary residence or a rental. It's kind of viewed the same. If you can't make the mortgage payment, then you're going to lose it.
There's an aspect of, there's another question about the role of the trustee selling assets, and then the portion of this question about how vulnerable principal residences are in liquidation. We haven't discussed the concept of exempt property. So the bankruptcy code allows debtors, individual debtors, not corporations, but individual debtors in bankruptcy to protect certain property from the reach of their creditors. The protection is in certain ways a lot more extensive than protection from the execution of judgments. It gets deep pretty quickly. But one of the major roles that the bankruptcy debtor's attorney has is to evaluate from their list of property, where they're supposed to tell you everything, what, if any, property may be lost or may be exposed to the reach of their creditors. And most of the time in bankruptcy, that's through the bankruptcy trustee selling the assets. California, as is the case in so many other, has quite consumer-friendly laws. And so we get to exempt a lot of property. And most cases that we file are non-asset cases, which is what we say when no money goes out to the creditors from the assets of the debtor. But it's something that you always have in mind. And if you represent debtors or creditors in bankruptcy, you'll become very familiar with what property can be exempted and with what property may be exposed to creditors.
Okay, we have one of the questions, kind of a 2-part about how do you recommend getting a mentor? And then what other backgrounds or practice synergies do you think would be helpful for a new bankruptcy lawyer? Well, on the mentor, I mean, I would say, you know, like I said, the bankruptcy section of the Bar Association that has most of the local bankruptcy attorneys. You know, you could just work through us. And then other practice synergies, I would say, I mean, like Vince mentioned, if you're numbers oriented, bankruptcy is definitely a little easier. I mean, other practice areas, I think, you know, I've seen some people who've previously done family law become bankruptcy attorneys. That helps out to a certain extent. I mean, Vince or Carl, do you have anything else to add on that?
I've seen some people who've gone into litigation and really have that as a strength in bankruptcy. It's quite different to do what's mostly a transactional practice, but within a niche area, litigation can work. And if you're more comfortable litigating, just make sure you get the tone of bankruptcy court before you unleash all of your weapons on what might not be thought of as a worthy case in bankruptcy. And then there's a lot of intersection with family law and occasionally estate law, but knowing property law generally can be really helpful, whatever area you come from with that knowledge.
Yeah, I would just add just a couple things. I'd say it depends on if you are brand new. You know, maybe if you're brand new to law and you're just looking for a new career, I'd say, yeah, if you have a financial background, it helps. If you have other areas that you currently practice and you're looking for the synergies, I'd say if you've got clients that are being sued and they're having judgments against them and they need to file bankruptcy, maybe it's a natural to add that to your practice. Also, obviously, family law. Sometimes people get divorced. They don't realize what it costs once they split up, and the expenses really drain both sides, and they end up filing bankruptcy after, you know, sometime after divorce. So sometimes that's a natural to do family law and then add some bankruptcy to the practice. But
Okay, so,
yeah.
Okay, so before we take any further questions, we're gonna switch over to hear from Jen Lee, our sponsor today. Her company is Lawyer Success Network, and she's also a local bankruptcy attorney.
Hello, I'm going to share my screen real quick, if that's okay. Let's see if I can find what I'm looking for. There we go. Okay, so my name is Jen Lee. I'm a local bankruptcy attorney. I know David, Vince, and Carl very well. The bankruptcy world is very congenial. But what happened a couple of months ago is I got asked to start helping others build bankruptcy practices from within my network. And so I did create an online workshop. It's approximately 15 hours of content, walking people through the software you need, admissions, the code sections that you need, the initial consultation process, the client workflow, and then also Chapter 7 and Chapter 13. There are model fee agreements in there, as well as lots of downloads walking through all the schedules. And then finally, how to market a bankruptcy practice. And has gotten great reviews. You can check it on the site. Contra Costa County Bar Association members get $500 off on the program itself. So that is a benefit as a member benefit provider that I offer. And I just wanted to put this out there because I did find that there's a lot of information out there, but no one had really packaged it together as far as how do you start and build from the beginning. So I appreciate you guys letting me sponsor today. And if you have any questions, my email is jen@jenleelaw.com, and I'm very easy available to ask questions of as well. Thanks, guys.
David, do you have more questions?
I don't think there are any more questions.
Okay, are we good? There's Mike. Okay, well, thank you everyone for attending. If there are no more questions, we're gonna say goodbye, and we hope you have a great rest of the day. Anything else, panelists? All good? Okay. All right, thank you, everyone.
Vince was speaking. You're muted, Vince.
One quick thought. I don't know any of the panelists. We have a lot of time to mentor, but we're happy to take questions. If you guys have one-off questions or a series of questions, we can certainly help. In terms of us being mentors, I guess they can answer for themselves, but I'm not sure we're going to have a lot of time facing, given that we're facing kind of a calamity coming our way. But
Yeah.
We're happy to take your call and answer any questions.
Yeah, just about that, a lot of people have the impression, so I've done bankruptcy for 12 years now, and people, wow, you must be so busy. And the answer is, yeah, kind of reconfiguring my office, work Zoom, right? Going through all those other things that everyone is going through. But the case workload has actually dipped pretty dramatically during this time. So